All right, listen, let's get into it. And our guest, to help us understand who gets what when a marriage ends, is, and I'm going to use his full name for the full gravitas, Barima Nana Yao Kodie Oppong. Have I said it right?
It's actually Kodie.
Kodie.
The eagle.
Yeah. Kodie. Oh, Kodie. Ah, yeah. Yes. Wow. Barima Nana Yao Kodie Oppong, who, of course, is the director of the Ghana School of Law. Mama B's headmaster. Ex-headmaster. That's right. Yes, lawyer Yao Oppong is our guest here on the Super Morning Show. So good to have you.
Yes,
good morning.
It's always a joy to come back to Joy.
Indeed.
Wow. So anyway, today by 9 o'clock we are doing orientation.
Oh goodness.
For our new entrance to the Ghana School of Law. 964.
Wow.
Personalities. So I may be in a rush.
Indeed, no doubt. So we'll try and get you through this one as quickly as we can, so we don't keep our new prospective lawyers waiting.
That's right.
All right. So let's get straight to it. What determines who gets what when a marriage ends and there are court proceedings?
Okay, I will start from the bottom. What does it mean to say a marriage has ended? Right. I mean, there are two main instances. Well, maybe three. One, where one of the spouses die. So when one of the spouses dies, then the marriage automatically comes to an end. And when there is divorce, also. And when there is annulment. Now, annulment comes in when, for example, at the time of the marriage, one of the spouses had already married, but he did not disclose that. In law, it is called void ab initio. It didn't happen at all because of the fraudulent misrepresentation or concealment of that fact. And it depends on the kind of marriage anyway. So if, for example, you've married under the customary law, or we wrongly called the engagement, which is a kind of marriage, and you go and marry another person under the ordinance, that's what we wrongly also call wedding. The second one is void.
Right.
Because at that time we were already married, whether under the Muhammadan law or under customary law. You cannot add even an ordinance married to it. But of course, if it's customary, you can add one to it, usually with compensation to the existing wife.
Right.
All right. So these are the three, but the two main are really where one of them dies or there is dissolution of the marriage. That's divorce, if you mean. So
today we'll kind of leave out the instance of when one of them dies. We'll focus on divorce and annulment.
Right,
and from your explanation, am I right if I say that basically divorce is when there was a marriage, but it is ended?
Yes.
And annulment is when it is discovered or determined that there was never a marriage at all.
Yes, because as I gave one of the examples is at the time the person was married, and by law he cannot be permitted to add to it. But even that will have to go to court for a determination. Right. So yes, you also spoke about who gets what. And interestingly, the courts have developed some principles for the determination of who gets what. The first one, which used to be the case in most cases, is what we call the substantial contribution principle. Yes, NCNC. And whoever contributes substantially will get substantial part.
Okay.
So the man may also tell the wife, use your income as chop money. And I believe everybody understands that anyway. And then he will use his own to build the house, let's say the matrimonial home. And also, sometimes you say that, well, if I buy a bag of cement, you will have to go to the site with food to the masons, so that becomes your contribution as well. You know, so, or maybe buy sand, whilst I buy the iron rods and things like that. Or use your money to feed the children, pay their school fees, and I'll use mine to build the house. That used to be problematic, especially for the woman or the wife, because in most cases the issues come around the house or the building or the property, and you are supposed to show evidence that you actually made not just a mere contribution but substantial contribution.
Right.
And if you fail to do so, you were likely going to be thrown out of court, or you'll be given some insignificant part of the property. And so over the years, it was found that was wreaking serious havoc to wives in particular. So they then came out over the years with agreement between the parties. That, the parties can agree that as far as we are concerned, my house in Achimodan belongs to me because that's where I'm from. And the one that you have also constructed in Tumu is for you because that's where you come from. Or by their conduct, they have treated the property in such a way that it is understood between them that this is for me and that is for you, or this belongs to me and that belongs to you. So that agreement can also be a determining factor. But we don't have the agreement before marriage, the prenup that people talk about.
Prenups don't exist in Ghana, is what you're saying.
Under the constitution, as it stands now, I would say that it may be declared an illegality.
Wow.
Yes.
You use may.
Yes, it will depend on how you also go to court and argue. But then it's because the constitution has now determined that it's property acquired during the marriage, the subsistence of the marriage, and where there is evidence of joint acquisition, that becomes the subject for distribution at the time of dissolution of the marriage. So if it wasn't, so that if even during the subsistence of the marriage or before, you agree that this property is for me, or when I acquire, let's say, 3 houses in Accra, 2 will belong to me, 1 will be for you. Because the constitution has set out the parameters for determination, it may have a challenge, especially where one person dies, which for me is bigger than even where there is dissolution. But maybe we'll find time to look at it.
But just so quickly, but I also have the right under the constitution to own property. So even in the marriage, I can I not?
Yes, so that is what we'll come to. And that is what led particularly a female Supreme Court judge to say that let's hang on. I mean, you cannot make a hard and fast rule about this, because under Article 18, the Constitution says I can acquire property either by myself, that is alone, or in association with others. So if you make a rule that once this property was acquired during the subsistence of the marriage, and the other person made no contribution of any form to it, and you say that it necessarily belongs to the two of us, then you'll be violating another provision of the Constitution, which is Article 18. You understand? Yes, so we'll look at it.
Wow.
But one of the things also that they look at is age of the parties. That's very interesting. So in one case, the court said that looking at the age of the woman at the time you married the person, and you were very old, going to retirement, you've wasted her time. And so in determining how much she will receive, and the marriage may have cost her some job because she has to concentrate on maintaining you, I think they still do substantially. Don't they?
Yes, we do.
Well, when it comes to money, they claim they do. Right. But on all other things, feminism reigns.
So they can look at the age and give you what is substantial in commiseration with the age and maybe waste of your time, as it were, quote and unquote.
But so that means the court perceives the woman's time as more valuable than the man's in a marriage?
No, well, I mean, except that the case that came out with this, it was in favor of the woman and her age. I haven't come across one of a man. And even knowing the position I have held over the years, and all my students know, I don't think that a man's age or any disability, quote and unquote, should be a determining factor. If it's for the woman, I have no problem with that. I know that I will still receive serious lashes by the time I leave here, but that is how you develop the law. Then the other one is the nationalities of the party, or nationality of the parties. If the person is not a citizen of Ghana, say you marry a Togolese or maybe Ivorian or British woman. By the constitution, the person cannot acquire a freehold in any land in Ghana. So if the property which is a subject matter of distribution is a freehold, then that person can only be entitled to 50 years at any one time. So that after the 50 years, it will revert to the original owner, being the husband, or the original owner from whom the husband acquired the property, if other conditions also occur. So the nationality of the party, so before you get married, you must be certain about who you are getting married to, the nationality, the citizenship, and so on. That can also affect it. Then the status of the relationship. The Supreme Court has held generally that this law, Article 22, maybe as we go on, I'll read it in full, only applies to persons in marriage, not in concubinage. So first, you must show evidence that you have married. And we have types of marriage in this country. Even under customary law alone, we have types. We have one that you have actually gone to perform the relevant customary rites. That is acceptable to that community or the area where the woman hails from. You understand? Because that, after all, is the definition of customary law. The law that is pertains to the particular community in Ghana. So if you do that, that's customary marriage. There is some that the law views in terms of the implied marriage, but also it's as good as the first one. If you go to funerals together, for example, you go and pay the Nsawan in your joint names, oh, you are paying this in Nsawan, it's possible that you attended, maybe your wife's mother died, not your wife, but this woman you are living with, the mother dies or uncle. You go there, hold yourself out as husband and wife. You pay in Nsawan, you conduct everything as if you have married the person by performing the customary rite. The absence of the customary rite, performance of customary rite, may not be the only reason why you be deemed to be husband and wife. If you hold yourself out in the eyes of the general public that you are husband and wife, you even go to church and pledge. But for here, you go and then you pledge that, oh, me and Madam Susu, so even if you don't call her wife. So when those things are put together cumulatively, it will there will arise a presumption, almost irrebuttable, that the two of you are husband and wife, even if you haven't yet performed. Some customary laws of various communities may still not see you as such. They even see it in Chi, they will call it kwasebu. Meaning if we have stolen our daughter, and the impunity of it also is that you come out here and you behave as if you're husband. But generally, once you conduct yourself as husband and wife, you may be deemed under the law. And there are a number of cases that has confirmed that. There are some cases that also hold that, well, it doesn't matter whether there is marriage or not. You'll be entitled to something, but it will not be under Article 22.
Right.
So the status of the marriage or the status of the relationship, whether married or not, may also have effect on even whether you are entitled to any share at all or the quantum. Then there's what I call the tracing or piercing of the veil principle. Now, so some ingenious, maybe I can still say disingenuous men in particular, if they don't want the wife to have a share, all you will do is that set up a company, and then his income will be invested in the company. And those who understand company law will tell you whatever property a company owns is for that company, even if it was part of your salary or your income that you invested in. The company owns the property. The company can sue and be sued in relation to the property. So by the time of the marriage, I don't have anything. But he owns the company. So the law is that we have to trace. First, are you trying to overreach the law by investing your income in it so that you have nothing to share with your spouse? So when they trace it and it pinpoints to the fact that you have invested all this in the company, then the law will say we will bring out some of this. And this case involves a very famous politician, and because of a lot of things that may happen tomorrow. Let me not, as if then I'll be categorized. I'll be, but I'm a chief, I'm not supposed to do politics.
What if you're not, what if you're not investing in a company, but you're investing in, say, your mother, your father?
Oh, well, I mean, even that, if it's a matter of fact, if it will amount to like this footballer did, I'm saying that in Ghana, he wouldn't have won the case, if at least if I was a judge. I mean, you have taken deliberate steps to overreach the law. You understand? And it will not be countenance. You will trace where the money went, because if you are a footballer, everybody knows how much, or a rich businessman like you, everybody knows how much you earn or how much you should earn because of the business you do. And during marriage, you say, I own nothing. I mean, you cannot.
But maybe he owns nothing because he has given it to his mother, who he loves and owes a debt of gratitude.
Which is a conduct that I share fully. But where it can be seen that, because even when you make a will, and it is seen that you deliberately denied a spouse her entitlement by giving nearly everything to other people, whether your mother, father, or children, without which your spouse cannot be able to maintain herself, the law empowers the judge to vary that will.
Right.
So that the person you have denied and who without that cannot survive will get a share, even in a will. All right, so because there are more interesting ones. Now, the conduct of the spouses. Should we take into account the cause of the dissolution? Because it is becoming regular or a trending matter where you are tired of the marriage. You know that you cannot get access to property unless it is dissolved. So else we are here, they will just bring a mistress home. This is my new girlfriend or side chick. I understand the equivalent for men is a cock chick or side cock.
Yes, side cock.
All right. And then, yes, so you'll be compelled to now go to court because adultery is a ground for dissolution. And then they claim your share in the property. But I have argued that no matter what, where a person deliberately causes one of these facts or grounds for dissolution to occur, then that person should not benefit from it. So the conduct of the parties, even though there have been cases where the judges, and I agreed with them in part, said that, look, if the person has earned a right, the other conduct, as despicable that it may be, or even if it's a serious aberration of what is right, should not affect the right that is already earned. The person has earned the right to have a share in a property acquired during marriage. If she engages or he engages in acts that will cause a dissolution of the marriage, that shouldn't have any effect on it. And there are cases, I've already told Samson to publish. This was a paper I gave at the bar conference in Cape Coast when I was asked to, express my thoughts on it. Then the source of the funds and the acquisition of the property. So where I go to the bank for a loan or other financial facility, then I use it to construct the property or acquire the assets. Then by the Supreme Court, it makes sense that I should pay off this debt before we can even consider whether we should share. Because in any case, it is not as a result of any contribution you made. It's as a result of me going to borrow the money. But hold on. If, for example, you went to borrow the money and you come home, your wife cooks for you, engages in consortium, which is too early in the morning. So we use technical terms.
Consortium,
yes. Without which you would have gone out to pay for a less satisfactory benefit or service. Yes, thank you. That person can argue that it's because of these services that you were able to even go to work every day and gain more money to be able to even service the loan in the first place. So is that not another form of contribution? That is fine.
Or let me even ask a more direct question. Let's say you're married to somebody whose lifestyle causes you to live beyond your means, for which reason you have to go and take a loan to maintain the lifestyle, and then there's a divorce. You don't share the liability.
No, well, but in the first place, you have to live within your means, as you said. I mean, of course, they say that to love and be wise, no more than to tax and be happy, is not given to men. In other words, there's no way you can be in love and be wise. So that is also is not coming from me. But my favorite, I have to jump a few because of lack of time, is the makeup of the wife. Is she beautiful?
Hey,
yes.
That also determines who
well,
gets
at
what.
least one judge did that, but it was later jettisoned.
Oh, I'm interested in this
one.
one.
He said that as I sat and watched the ex-wife come in and go out of the court, I think she is an exquisite specimen, not only of womanhood, but of creation itself. 20 years of her youthful and fruitful life is now wasted. To that I shall return. The ironclad evidence and potency of the respondent's evidence is such that the petitioner cannot have his way forever. Indeed, the petitioner cannot kick against the pricks of solid evidence of substantial contribution by the ex-wife.
Hey, so the beauty is a substantial contribution to the marriage and must be.
Well, as if you have wasted the time and her beauty. But of course, subsequently, the Supreme Court didn't think that was a good ground. But I mean, they are human beings. They also watch parties come to court. And if they think they are beautiful, and for that matter, there should be some concessions.
Wow.
Yeah, I think that can be. So these are some of the few pillars on which they can found a claim for contribution. And of course, there are more. But I go further down to creation itself. All right. So if you take Genesis 3:16, 19, and then 21, unto the woman God said, I will greatly multiply thy sorrow and thy conception. In sorrow thou shalt bring forth children, and thy desire shall be to thy husband, and he shall rule over thee. This is the responsibility God gave to women. Now, of course, married women, because it says wife. Then unto the man, this is what he said. In the sweat of thy face shalt thou eat bread, till thou return unto the ground. For out of it was thou taken. For thus thou shalt act, and unto thus thou shalt return.
Amen.
Then he goes on to say, that is why a man will go to another house to pick up a woman and make her his wife. So the sweat, the result of the sweat is not just for the maintenance of yourself only, but the wife, her responsibility is to go through travails for 9 months if she's lucky, sometimes 10 months, and sometimes twins or triplets or more. All the pains they go through is their responsibility. So if on top of that, as it were, you still want NC, equal share, I have a problem. Then customary law is even, I would say, is worse. It's even more on point.
In fact, just before Lawyer Oppong walks us through what the customary pillars are of who gets what, let me just quickly remind you of what we've learned so far. We've learned that there are several pillars. I can't go through them all. So many of them that determine who gets what when a marriage ends. But one of the interesting revelations is that prenup may not be a legally recognized arrangement when it comes to marriage in Ghana. People are reacting to that on social media because there are lots of people who are married and they believe they have a prenup and they are realizing that their foundation is shaky. But there are other things we've learned, and we'll do a summary when we're done. But we have a very limited time with Lawyer Oppong. So let's get straight to the customary pillars.
Okay, so because of lack of time, let me just refer you to a declaration made by J.B. Dankwa in a famous book that he's written on customary law. I mean, it's outstanding. And this is based on observations that he did among some communities in Ghana. And he says that our system of succession bars a husband from the enjoyment of his wife's self-acquired property.
Wow.
For a wife's personal property is, as a whole, her own family property. And when she dies, her family will take all of it from her husband's control. And it makes sense. Let me ask you, if your wife, touch wood, were to die, and family members come to you, oh, our in-law, we have come to take assets of our wife. Did she also build a house somewhere? And you say, Penny, have you not heard of Article 22 before? Or PNDC Law 111 and the like? This is my wife's property, and I have a share in it. Just attempt this exercise. Or, because you don't want your wife to die, just on dissolution, make this argument. Depending on where you come from, the insults will the insults will be in grade. Like a place very near us here.
The closer you are to the capital,
you dare not. Now, that is why I argue that, you remember a very famous man wore a jacket, and just because the button or the zip was on the other side,
he said it was his wife's.
Yes. He was a toast. I mean, he was so much ridiculed. But if a woman had worn the same thing, nobody cares. Where I come from and across to Kumasi, they call it mata. A mata there. Just because even the zip is facing on the left, they will laugh at you. Because it is an abomination for you to even lay claim to your wife's property.
Why?
It's an abomination. That has always been the case. Because, you see, when you went to the person's father's house to say, oh, Penny, I've seen a flower here, referring to the daughter, and I want her to join me in my house so we can make a family. Unknown to them, you wanted a joint ventureship with her and not a marriage.
So a marriage is not a joint venture?
It is not. It ought not be. It ought not be. That's why I argue that it is the responsibility of a man to maintain the wife and the children if there are any, or a child if there is any.
Okay.
There is no correspondent duty on a wife to do the same. And that, for me, runs through generally.
So,
yes, sir.
Is it the case also that it is the responsibility of the wife to submit to her husband?
Well, I mean, if you read the Bible, I mean, the Genesis that I referred to, it says, and the man shall rule over you. That itself, that has its own interpretation. That can, the word rule itself, and then, of course, what you said was said by Paul. I mean, one of the most intelligent, well-read, a lawyer and all that. That also has its own interpretation.
Yeah, but my question is, because you're saying this is an abomination. So if you go and marry, and since we are making reference to the customary law,
yes,
within that same customary practice also, a woman is expected to be at the service of her husband. And I am asking, is that the case? Should that be the case?
Well, not necessarily. Not necessarily. In fact, if you want to know any group of people who respect women and don't see them as servants, is the entirety of the Ghanaian population, the community. That is why when men meet, even in Ahimfie and there's a tie, they can't find a solution to any issue before them. They say, Yenko Hua Brewa. That is the proverbial wise woman who is superior. And that is why when there is a vacancy on a stool, it is the Ohima who has the first right to nominate a man or a woman, if it pertains there, to be a chief. So we have never deemed women to be servants or slaves or persons whose work only is to serve us. That has never been the case. But in a community, you may have people who raise certain abnormal conduct to become normal conduct. So I don't share the view that at customary law or within the communities, but there's a joy for a woman to serve the husband. And I say that some people argue, why is it when you are coming from the farm, the woman has a baby at her back, has some heavy laden on her head, and the man is holding a cutlass and singing, she. Then somebody argued that But the man has a responsibility as a security man. In fact, the shame of allowing a wild animal to attack your wife because you may have been carrying heavy load. That alone. So he has to also maintain his duty as a security man. Even though it is unconscionable to overburden the woman who already has a baby. I know some men who put the baby on their neck whilst perhaps the lady, the woman has, or share it. But now I argue that with Abubuya and roads constructed to farms, all these things have been reached. So other people have held these views, which for me sometimes is unconscionable, as I said. But to answer your question directly, I don't think there is any customary law worth a salt that deems a woman's worth only to serve. But women are generally persons who serve. There are people, professors, I know, women, who will never allow anybody else to cook for their husband, anybody else to wash their underpanties, even if there is a domestic engineer, if you like, a maid in the house. They would definitely want to just cook for their husband because there is that joy in it. So that's just the answer to it.
So just to okay, to sum up.
Yes.
First of all, when it comes to the courts, it seems that the marriage or the dissolution of marriage favors the woman more than the man. When it comes to customary law, it seems to be the same thing, that it is designed to favor the woman more than the man.
No, on the contrary, the courts don't usually use some of these things. I'm talking about my own views,
right?
But now the courts just look at Article 22. Let me just quickly refer to it so that we will see what the Constitution says about it. So for that, they just look at what does Article 22 say. We say a spouse shall not be deprived of a reasonable provision out of the estate of a spouse, whether or not the spouse died having made a will. Then, with a view to achieving the full realization of the rights referred to in Clause 2 of this article, spouses shall have equal access to property jointly acquired during marriage. Unfortunately, Parliament is yet to comply with the provision that says they must pass a law to regulate this area. Then and do you know why? When you meet them, ask. Probably, somebody said that the female won't want their husbands who are poorer to have a share, and the man don't want their wife who are poorer to. But the Constitution has imposed a duty on Parliament that Parliament shall, as soon as practicable after the coming into force of this Constitution, enact legislation regulating the property rights of spouses. It's 30 years now. The closest they came was to bring a few ones in the Land Act, but that is not sufficient. So ask yourself. So I argue that if you go by my opinion, that law will be passed because the women will agree that we will be keeping our property and at our own generosity or magnanimity, but we know for a fact that our wives go beyond the mere acquisition of property, maintain our children, and after birth, they obviously lose a lot.
But don't men,
even of flavor,
don't men lose? Don't men also give to a marriage? Don't they sacrifice?
I'm not saying that use all your
don't
property.
They break their backs?
I'm not saying that if you read the article, I'm not saying that give all your property to a woman. I'm saying that it is your sole responsibility to maintain the house. It is also your responsibility. I mean, that will include taking care of the student, the children in school, in trade, in business, food, clothing, all the necessaries of life. It's your sole responsibility. But we know our women make such contribution. But in addition, you should also have a reasonable funds to take care of yourself because you need to maintain yourself as well. I mean, have a little fun, buy what you think will make your heart gladden. Then whatever is left is what you should share with the woman. But there's no correspondent duty on a woman to do an NC, no contribution, no chop, or equal contribution, or substantial contribution with you.
Lawyer Oppong, are you seeing the possibility that in if your opinions become commonly accepted, that men might fail to see the advantage of marriage?
That would be shameful.
Start having children, without
that would be
marriage.
But that would be shameful, because then it means that the purpose is not that you love someone and you want to marry the person, but you want somebody you should have a joint venture with, so you can, then that's why you don't need marriage. You can always, as Article 18 says, always get another person, form partnership and acquire property. But it will be shameful that because I'm saying that it is better and has always been consistent with the generally known customary law and even biblical principles, that the first principle is that it is your sole responsibility to take care of the wife and children.
Yeah.
And because of that, you say that I'm not going to marry. That will expose your actual motive
But
for
it's
getting into marriage, just to acquire properties, and not because you love someone or you want to live a quality life with the person.
But is that not rather now the motive of the woman to enter marriage to acquire property, if your opinions are to be accepted?
Oh well, I mean,
as the
if you
norm?
understand tree well, it's okwa warrior. Unya ka be mane dia, unya dia fabrefi. Did you not know that before you went into the marriage?
So that is the intention of the woman, to enter marriage and acquire property.
That has never been the intention of the. If you know how women behave in marriage generally, that has never been the intent. But that is the general position of customary law, that you must exercise your function. That is why it is you who will go to her house, expend money, engage in expenditure of money and other resources, just to take somebody's wife, somebody's daughter or child from the house, and not the other way around. You want the woman to now also equally. So let me just conclude on this, so that
the time is fast.
Yeah, but we can always come back. So this is just how I conclude. It is sad to have to note that instead of enhancing the limited powers, capabilities and opportunities for acquisition of property, which our illustrious women in particular are, in comparison to their male counterparts, generally unequally circumstanced to possess, and or instead of affording our women unhindered access to property that they are able to eke out by following and adhering religiously to the tenets of, for example, for a purpose, the Bible and custom and practices, we have rather fashioned out statutory rules, including the Constitution and also case law, which have failed to follow the path charted by the biblical rules and customary law as shown above. And when one of the eminent drafters of the Constitution got this article, he sent a message to his grandson, another prominent lawyer, that I didn't know until now, that when we were crafting Article 22, it was for the benefit of men more than for women, because women have always had limited rights to property acquired by the husband, but men didn't. Now men are so bold in court. This is my wife's property, I also want 50% share, I want equal share. Well, as far as I'm concerned, you have no business.
I need no other argument.
Mavi, when we come
May
back,
I
we
be
will get
discharged?
into the argument. We'll have to dissect this when we come back. Lawyer Oppong has to leave us, unfortunately. But my goodness, you've certainly cast the cat among the pigeons, and we'll be dealing with that after.
We're always available if you.
We have to do this.
We have to bring you back. We have to bring you back for more.
But please let them be charitable when they are lashing at me.
Barima and Kodie Oppong is the director of the Ghana School of Law. He's been our guest on this.
Just before we end, I mean, we are going to organize what is called legal clinic,
right,
at the Ghana School of Law. I think 24th November. So you can invite your listeners, that whoever has any matter that law is what can be applied to resolve, they can either send them to you. We can save it and invite such person to the Ghana School of Law We'll try and resolve these matters for you. If he has to go to court, we are prepared to do that from our legal department for free.
Wow.
Just to give it back to society.
Oh,
So
that's a great
24th,
initiative.
occasionally you can make the announcement, and it doesn't matter what the matter is, unless it is not something that is resolvable by law. But if you need law or lawyers to even advise you, just send the matter here. We will receive it so that we don't get too overwhelmed.
Yeah.
And those that are resolved just by a phone call away, we can just call you and say, look, this is how your matter can be resolved. But if we have to, because at the same time, our students should have the benefit of how even lawyers take a call from a client to look at it and even take it to court or resolve it. There will be judges on the table. There will be lawyers, senior lawyers on the table at the Ghana School of Law, and we will help to also give back to society. At the same time, our students will be learning as well. You didn't have the benefit, but you can still come back if you don't mind.
Please don't give her more legal education than you already have. Thank you so much, lawyer Oppong, Barima and Kodie Oppong, director of the Ghana School of Law. He'll be back on the Super Morning Show for us to do even more.